about it. So I understand that you have combined academic and practitioner career. We've already shared some discussion about academic interests in common. So prior to your election to the European Court of Human Rights in 2013, the judge was a full professor and a dean at the Faculty of Law at the University of Iceland. He was a district court judge in Iceland, a member of the Judicial Supervisory Board, a member of the European Committee on Crime Problems, and an ad hoc judge of the EFTA Court. He is an author of a number of very influential publications discussing the European Convention on Human Rights and the European Court of Human Rights. And I'm sure we're all, those of us who are able to stay, are very much looking forward to what you have to say tonight. But again, on behalf of the School of Law and Social Justice, very well welcome to the University of Liverpool. I hope you enjoy your stay here, and I wish you a successful evening.
Thank you very much, Dean. Thank you very much, Dean Morris. Good afternoon, everybody. I'm very happy to be here. I didn't know until just now that I am a pioneer as the first judge in residence. I have never been a pioneer, so it's good to be first in doing something. I'm going to talk about, as the lecture is called, the historical trajectory of the European Court of Human Rights. It's a big title. Diplomacy, Subsidiarity, and the Rule of Law. I asked the professor what was the level of knowledge in the room on the European Convention. I will proceed on the basis that it's somewhere in the middle, so I won't be talking absolute basics. But I will try, when I speak about certain terms, maybe to give a bit of an introduction to what I'm going to talk about. Just a few things that I want to say, however, at the beginning. I am not in any shape or form a part of an institution which is a member of, directed at, influenced by the European Union. There is no Brexit hovering over this lecture at all in any shape or form. Perhaps indirectly, as I will mention at the end. I want to proceed in 4 parts. I want to begin first by giving you historically a description, a purely empirical description, of the history of the court. It is 4 phases in the life of the court that I want to talk about. Secondly, I want to discuss the current phase in the life of the court. I want to put it a bit in a UK context for those of you that are interested in human rights, the Convention, the Human Rights Act, and so forth. Thirdly, I want to speak about a principle which is called the principle of subsidiarity within the Convention system. This is not the principle of subsidiarity under EU law, for those of you that are EU law specialists, and the relationship between this principle of subsidiarity and the fundamental principle of the rule of law. And finally, in my 4th and last part, I want to say a bit about what are the main challenges for the system of human rights, the European Convention on Human Rights, in particular, the way that those challenges manifest themselves in different permutations of the rule of law principle. The way the system of human rights in Strasbourg is now confronted with various challenges which require a considered and thoughtful approach by the court and also by stakeholders at national level. I will define for you later on what I mean by stakeholders. So 4 different parts. The first part, the historical trajectory of the court. Just over 3 weeks ago, the court celebrated a birthday, celebrated its 60th birthday. The court was established in January 1959. The Consultative Assembly of the Council of Europe established the court. The convention is 9 years older. The system, the adjudicatory body, the court did not come into existence until 9 years after the signing of the convention in 1950. The first phase of 4 in the life of the court is a phase which begins in January 1959 and ends in the beginning of the 1970s. This is often termed the so-called diplomatic phase in the life of the court for various reasons. One of them is that the court was then a very little-known international institution, in many ways the first of its kind. It was a regional human rights court. It was occupied by the victors of the Second World War. These were states to the west, Nordic states, the UK, France, and so forth. And most of the judicial members, the judges of the court, were academics or individuals with a lot of diplomatic experience. They had either been part of delegations of the member states that founded, drafted, and formulated the convention. They were statesmen of their era. They were, of course, elderly white males, rather conservative. And the idea of a very robust and activist court was not at all on the horizon of these individuals. The court was little known also in the sense that the court did not have a lot to do in the first 10 to 15 years of its life. The first case, actually, of the court, it has a very interesting name because it's the case of Lawless versus the UK. So the first applicant in the life of the court is a man called Lawless, which is actually quite ironic. The second phase in the life of the court starts in the 1970s. One doesn't necessarily pinpoint the actual year, but I would say sometime 1973, 1974, the second phase, the so-called judicial phase, this is a term used by Professor Ed Bates of Leicester University in his book on the evolution of the convention. He calls the phase from the 1970s to the end of the 1980s until the fall of the Berlin Wall in 1989, he calls this the judicial phase. The reason is that this is the phase in which the court becomes basically what it is today. It becomes a court, an actual court. It develops all of its big principles, the living instrument doctrine with the case of Tyre versus the UK, the principle of subsidiarity and the margin of appreciation in a case called Handyside versus the UK, all of the big cases, the recognition of implicit and autonomous rights in Golder versus the UK, many UK cases because UK was a big state, still a big state, but was one of the big states of the convention in those years. One may ask, why did the court, and why was the court able to progress in that manner in the 70s and 80s? Well, the reason, I think, one of the reasons is the 70s and 80s was a time of integrationist politics, a time of the fruits of globalization, the ability and the recognition of states that collaboration across boundaries, limitations of sovereignty to be able to interact with the outside world were considered to be a good thing. What happens at the same time within the European communities? We see the same kind of trend happening with the Luxembourg Court in the Court of Justice. All of the seminal judgments of the European Court of Justice are also rendered in the 70s and 80s. Van Genten laws on direct effect, the supremacy doctrine, and so forth and so on. So the point I'm trying to make is an international institution like the Strasbourg Court, like other international institutions, do not operate in a vacuum. They are part of the international fabric in which they are situated. And one has to understand their historical trajectory vis-a-vis the environment they are a part of. The third phase in the life of the court is a phase which can be termed expansion to the east and the explosion of the caseload. 1989, we see the fall of the Berlin Wall, we see the fall of the Soviet Union, we see the transitioning of the Eastern Europe, the Central and Eastern European states towards the West, in a sense that there was an increased transitioning of democracy, and we see a number of states becoming a part of the Council of Europe. The Council of Europe exponentially expanded with totaling now 47 member states, and the commensurate increase in the caseload of the Strasbourg Court, which culminated in 2011 in 160,000 pending cases. Before that, the states had decided that the old system of division between the old court and the Commission had to be reformed. And this was done by Protocol 11 to the Convention, which came into force in 1998 with the establishment of the current permanent court and the abolition of the European Commission on Human Rights. In this third phase in the life of the court, the expansion to the east, the court has already espoused and formulated many of its general principles, and has also, and this is important, has also given life to most of the convention provisions in a manner encapsulating the minimum guarantees required under the convention. It goes without saying that many of the states to the east that became a part of this human rights environment, this collective system of guarantees, were not in a situation of being able to live up to the requirements of the minimum guarantees, and therefore the cases starting piling up in Strasbourg because lawyers, judges, politicians, NGOs, civil society realized that now Strasbourg, the Council of Europe, and the court were a remedy, a venue for relief, which was not in existence at domestic level. And this, then, in the beginning of the millennia, created a need for further reform. Because it goes without saying that a court with tens of thousands of cases is not going to be in a position to expeditiously resolve these cases in a manner which is commensurate to the right to a speedy or decision within a reasonable time. So beginning in 2002, 2003, the state started a reform process which culminated in the coming into force in 2010 of Protocol 14. Now this protocol is the basis upon which we, and I say we as I am a part of the court now, we have been able to reduce the caseload from a max total of 161,000 cases in 2011 to the current situation of 56,000 cases, which still is a huge amount, but it's still 100,000 cases less than we saw in 2011. The main reason for that is that Protocol 11 allowed us to institute a regime where each and every one of us as single judges are able to dismiss cases by ourselves without being a part of a multi-member composition. So that means that many of us, and I did this for many years, we were in a position to dismiss 300-400 cases every 2 weeks based on work done within the registry of the court, assisting the judges in finding cases which were manifestly ill-founded or were dismissed for other formal reasons. But still, the bulk of the problem remains, and I will come back to that at the end of my lecture. The fourth phase and the current phase in the life of the court starts around 2010, when Protocol 14 comes into force and the so-called Interlaken process begins. The Interlaken process is a process of high-level intergovernmental conferences which began in Interlaken in Holland in 2010, Switzerland, sorry, then went on to Izmir in Turkey, and then in 2012 to Brighton in the UK. And Brighton culminated in a declaration and the subsequent Protocol 15, which is just about to come into force. Protocol 15 to the convention will, for the first time, introduce the concepts of the margin of appreciation and the principle of subsidiarity within the convention text itself. So the current phase in the life of the court is a phase in which the court is, to some extent, looking at the challenges it faces and finding, perhaps, a strategic solution, and now I'm speaking more in terms of viewing the case law as we have seen it over the last 5 or 10 years, in terms of how the court can, to some extent, deal with the number of cases before it, and to what extent it can incentivize national stakeholders to take part in the process of protecting human rights at national level. So that brings me to my second part, which is the current phase of the court and a phase which we can call the subsidiarity phase, the phase in which the court is attempting to, in its case law, to try to find ways in which domestic human rights protections become more robust, become more stronger. A culture of human rights is created at national level so as to alleviate the burdens of having to wait many years for the resolution of cases at Strasbourg. What I want to make clear when I talk about subsidiarity is there is a right way to talk about subsidiarity and there is a wrong way to talk about subsidiarity. Let me explain what the right way to talk about subsidiarity is. It is the following way. The convention is based on certain foundations. Article 1 of the convention states that it is for the high contracting parties to protect and secure the rights in the convention. The convention is therefore an international treaty that must be operationalized at ground level in the states themselves. It is for the states, their governments, their judicial authorities, the executive and parliament, to protect and secure the human rights of their peoples. The main obligation to secure convention rights is not the court in Strasbourg. The problem with that foundational concept in the beginning was that within the nation states, the culture of human rights, the legal language of human rights, was limited to non-existent. In the 60s and 70s, human rights as an independent discipline of law was virtually non-existent, especially in academic circles. Lawyers did not learn independent disciplines of human rights in those years. Judges did not view the law through the prism and the language of human rights at that time. So therefore the court in the judicial phase had to create the edifice upon which the convention is based. So the judicial phase in the life of the court was the phase in which the building blocks for the future were laid, so the states themselves and their national authorities could take up the mantle and protect human rights, which was the original view of the foundational scheme under the convention. The court has, and now I'm going to be a bit more technical, the court has done this in several ways. Now, when I say the court has done this in several ways, I'm expressing my personal viewpoint. I'm expressing my own analysis of the way in which one should read the case law of the court in the last 5 or 10 years. one can adopt different viewpoints, and one can view that case law through different lenses. Absolutely. One, I propose to you to view it in the following way. One way in which the court has begun to try to incentivize national authorities is to, instead of deciding the case in Strasbourg as a first instance human rights tribunal, which views top-down the problem and tries to solve it by itself and provide an answer which is the one and only answer to the human rights problem in question, the court tries to fashion its case law prescriptively in grand chamber judgments to provide for guidance for the national authorities when they have to deal with similar questions. Let me take an example. Very recently, the court decided a case which, for those of us in this room that use email and online apps, which I think all of us do, will find important, is a case about a person who works in a Romanian company, a private company, a sales manager who used an instant messaging service set up by the employer. He was supposed to use this service only for work-related reasons, but decided to use it for personal reasons as well. When that was discovered, he was dismissed from his job. He came to Strasbourg after having lost within the national judicial system and said that dismissing him by looking into the use of his instant messaging account and reviewing his personal email was a violation of his right to privacy under Article 8. The Grand Chamber found a violation of the Convention. Why that was the case is beside the point for now. You can read the judgment. It's Barbulescu versus Romania. What is important that the court could have done it in different ways. The court could have simply looked at the issue, decided that a fair balance had not been struck in the case, and found a violation. The court did that, but what the court did first was, the court said, when this issue is examined, there are 6 criteria the national courts must look to. The court was doing that for a reason. The reason was that this case is only one of many. And what the court is trying to evade or trying to assist with this kind of prescriptive analysis in its judgment, it is trying to get the national judges to do the job that the Convention requires, which is deal with the human rights issue in a manner which is robust, which actually provides an incentive for the human rights issue to be adequately dealt with and not disregarded. Because at the end of the day, the question of whether a human right has been violated under our system of government is an issue for the courts. The courts will decide, and legal reasoning has to be applied. And what the court is doing with this kind of prescriptive analysis in its judgments, it is trying to assist the national judges in doing the job first, because the idea is that if the national courts do the job, well, on balance, probably they will be able to manage to reason themselves to an outcome which is convention compliant. Well, the Strasbourg court will always be there to have a say. Court is not abdicating its role at all. It will look into the reasoning given by the national courts, but at least it will do it not in a vacuum of emptiness and silence on the convention issue. It will at least have already work done at domestic level, which is the basis upon which Strasbourg judges can then review the convention issue in question. The same applies to parliaments. There is a growing case law of the court in which it's an underdeveloped case law at the moment. It is in its infancy, but there the court is giving some credence, some worth to parliaments actually debating human rights issues, reviewing the human rights elements of their legislation which can be seen from committee reports, preparatory works, and so forth, to try to, again, incentivize parliaments to create internally, within their domestic political culture, a culture of human rights protection. Now, this may sound utopian, but at the end of the day, at least if you do not try to incentivize parliaments that they can actually get something out of dealing with the human rights issue at the level of international adjudication, well, at the end of the day, nothing will be done. I mean, there needs to be some mechanism upon which an international institution will look into, will assess, will examine whether Parliament has at least attempted to review the pros and cons of a certain parliamentary debate. This fourth phase in the life of the court, and now I come to my third part, is in many ways problematic. The reason is that for a robust principle of subsidiarity to work, for this kind of logic in the development of the court's jurisprudence to be ultimately successful, the court's interlocutors at national level need to fulfill certain fundamental criteria. In other words, the principle of subsidiarity, this trajectory in the life of the court, is not sustainable unless the recipients and the participants at national level proceed on the basis of fulfilling certain foundational elements of the rule of law. In other words, if the Strasbourg judge is not interacting with a judge domestically who is independent and impartial, then the symmetry, then the symbiotic relationship between the two, which is the ultimate aim of the system, will not come to fruition. There is therefore a very strong correlation between the principle of subsidiarity and the foundational, I say foundational for a reason, principle of the rule of law as encapsulated in the preamble to the European Convention on Human Rights. What I mean by this is the European Convention on Human Rights is not neutral when it comes to the system of government that should be the basis upon which decisions are made in the member states. The preamble to the European Convention on Human Rights makes explicit reference to the principle of a constitutional democracy as the foundational system of government under the Convention. Now, this has a number of consequences. One is that the Convention requires pluralism in political decision-making. The Convention is anathema to authoritarianism. The Convention does not recognize abusive concentration of power. The Convention encapsulates the system of the separation of powers. The Convention protects and preserves a system of checks and balances because the usurpation of power is the ultimate denigration of individual liberties. The principle of subsidiarity, for it to work, it must therefore be exercised at domestic level within a system of government that fulfills these foundational criteria. Because if not, the system, the principle of subsidiarity, as a system of the Strasbourg court granting any kind of deference to a national system becomes limited or non-existent. So therefore, we are now in a system, we're now in a situation where the court is moving in the next years into its fifth phase in its life. And now I'm into more of a predictive type of analysis of what the challenges the court is facing. And I want to try, in my sort of last part, to try to describe in better terms what I mean by that, and what the court is facing and how it's meeting those challenges. I mentioned at the outset that, and this is the third adjective in my title, the rule of law, and that is the challenges facing the court is a challenge of finding the balance between creating a sustainable system of human rights protections, which is a system which is operationalized at ground level within a situation, a progressive situation of the erosion of the rule of law, which is the commensurate other side of the coin of a future which is sustainable in this system. The court has always attempted and continues to attempt to formulate collective principles of human rights which apply equally in the 47 member states. It is an unsustainable system of adjudicatory mechanism if the system is disjuncted, if it becomes internally imbalanced. Law is a discipline of coherence. What we've seen in recent years is the rule of law concept as coming again to the forefront in international human rights law. The rule of law is something all of us in this room, every lawyer knows or pretends to know what the rule of law means. There are many manifestations to it. And the court has not, in fact, given any clear articulation of this concept. It is almost as if the rule of law had become a cliche, had become a self-evident truth. But I submit to you that the biggest challenge facing evolution in international human rights law, and certainly under the convention system, is to articulate in concrete terms what are the individual manifestations of the rule of law, and to attempt to articulate that view in judgments which are concrete and provide protections. And now I want to present to you a few of the manifestations of the rule of law in contemporary jurisprudence of the court. The first one is the principle of legality. Any interference with a convention right must be prescribed by law. This has usually been termed a foreseeability assessment based on the quality of the law in question. There, I think, the rule of law has one of its ultimate manifestations. Because within a system where the rule of law is being eroded, one of the manifestations of that development are laws being couched in general, abstract, and vague terms so as to encapsulate, to encompass situation, factual matrices which are unclear and not easily ascertainable. in recent case law of the court coming from some states, I would venture to propose to you that the court is progressing with an analysis of the quality of the law to take account of these developments. Secondly, there is a general principle which permeates the convention, and that is procedural protections must be robust as a measure against arbitrariness. That is also a clear manifestation of the rule of law. And the court is developing that area in several ways. One of the issues now the court has to look to is to what extent measures of intrusion into the lives of people's, for example, government surveillance and so forth, needs to be met with ever closer scrutiny with procedural measures adopted in domestic laws. Thirdly, we have seen in recent years an evolution in the jurisprudence of the court under Article 18 of the Convention. Article 18 provides that no state can limit convention rights for other purposes than those enumerated in the Convention. Article 18 is to protect against the political abuse of rights. And up until rather recently, Article 18 was a rather underdeveloped provision of the Convention, the court having found very few violations under that provision. We are seeing, and I say unfortunately, we have seen in recent years and recent months the court going further with grand chamber judgments against some states under Article 18 and finding violations based on the political abuse of rights. And the use of Article 18, it has, of course, a stigmatizing character, and that is why the court has developed its jurisprudence very carefully. The fourth and last, but not least, manifestation of the principle of the rule of law is the independence of the judiciary. And there I think I can safely say that in the last